Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an important update from the Delhi High Court, which today heard Chief Minister Arvind Kejriwal challenging his arrest by the Enforcement Directorate and 6 days of remand in the money laundering case related to the alleged liquor policy scam case. Justice Swarnakant Sharma heard the matter today. As you already know, Kejriwal was arrested on 21st March. Next day, the trial court remanded him to ED custody till 28th March. During the hearing today, the Additional Solicitor General S.V. Raju, representing ED, informed the court that the agency had received copy of Mr. Kejriwal's petition yesterday. As a result, he requested a 3-week extension to prepare and file a detailed reply on behalf of the ED. Senior Advocate Abhishek Manu Singhvi, representing Kejriwal, raised objections to ED's request. He stressed the urgency of the matter, particularly because Kejriwal's remand is ending tomorrow. Singhvi contended that Kejriwal's arrest infringed upon his human rights and accused ED of pursuing politically motivated actions. He criticized ED's delaying tactics, alleging an abuse of power. Additionally, he questioned the reliability of the potential approvers in the case. In response, ED insisted on the agency's right to file replies on both the main matter and the petition for interim relief. Justice Swarnakant Sharma, however, declined any relief for now and issued notice on Kejriwal's interim application seeking immediate release. To know more about this, please visit livelaw.in. Also, let me tell you, a letter petition has been filed in the Delhi High Court challenging the protest by Aam Aadmi Party's legal cell against the arrest of Chief Minister Arvind Kejriwal. The petition refers to certain tweets made by the lawyers calling for massive protests in the courts in the national capital. When the matter was mentioned today before the bench led by Acting Chief Justice Manmohan, it said that the matter would be taken up tomorrow. The Madhya Pradesh High Court has given protection to a couple, both aged 19 years, living together. However, the court also warned young people about starting relationships and leaving their families too early in life. In this case, the couple had filed a petition requesting authorities, including the local police, to provide them with protection and support against potential threats from their family members. Additionally, they sought assurances against any false charges from being filed against them. The government advocate opposed the petition and submitted that the petitioner boy was only 19 years old and he had not even completed 21 years, which is the marriageable age, and that if such protection was granted, it would not be in the larger interest of the society. But the court placed reliance on the Supreme Court's judgment in Nandakumar versus State of Kerala, where the apex court had pointed that it was sufficient that both the parties were major, and even if they were not competent to enter into wedlock, they had the right to live together even outside wedlock. Thus, as the petitioners in the present case had attained the age of majority and affirmed that they were acting out of free choice, the bench of Justice Subodh Abhyankar granted them the protection. However, the court expressed concern about the choices young people are making today. It highlighted that in India, where there is no financial support from the state for the unemployed and uneducated, young individuals choosing to live independently from their parents must bear the responsibility of earning for themselves and for their partners. This choice often means sacrificing education, which can affect their opportunities, social acceptance, and for young women, the risk of early pregnancy adds further challenges. Justice Abhyankar thus emphasized the importance of careful consideration before making such life-altering decisions. The Chhattisgarh High Court has registered a suo motu PIL to explore the possibilities with regard to implementation of open jails and to ascertain whether the same would be feasible in the state. An open jail is a type of a prison where inmates are not kept in traditional cells but are allowed more freedom and autonomy within a less restrictive environment. These facilities operate on the principle of self-discipline and trust, with the belief that treating inmates with more humanity can aid in their rehabilitation. Earlier, the High Court took cognizance of several letters written by relatives of a murder convict stating that because of confinement of the sole bread earner of their family, they were living a life in misery. Pursuant to the aforesaid letters, data was collected from the central jails and district jails. Upon perusal of the data, the court noted that 82 children were living with female prisoners in jail. There are 340 convicts who have been convicted for more than 20 years of imprisonment, and their appeals have been dismissed by the Supreme Court. That the total capacity of jails is 15,485, against which 19,476 prisoners are confined, and a total number of 1843 prisoners are skilled professionals. 504 are senior citizens, and 4 prisoners have tried to escape the jail. The court noted that the concept of open jail was not new in India, as the state of Rajasthan, Maharashtra and Himachal Pradesh have the maximum number of active open prisons. The matter is listed again on 15th April. Stay tuned. In another update, the Enforcement Directorate has informed the Kerala High Court that its probe into alleged irregularities in Masala bonds floated by Kerala Infrastructure Investment Fund Board, that is KIIFB, is being delayed since August 2022 due to non-cooperation of former Finance Minister Dr. Thomas Isaac and officials from the KIIFB. In an affidavit, ED has stated that Dr. Thomas held important positions in committees responsible for deciding how funds from Masala bonds would be used. Despite being summoned and directed by the court to assist with the investigation, he did not appear or cooperate. ED further alleged that Dr. Thomas was giving statements to the media challenging the authority of the court and other officials. Let me tell you, Masala bonds are rupee-dominated bonds issued outside of India by Indian entities. They are typically used by Indian corporations, banks and financial institutions to raise funds from international investors. These bonds allow Indian entities to raise capital from global investors without being exposed to currency fluctuations, as the repayment and interest payments are made in Indian rupees. In this case, separate pleas were filed by KIIFB and Dr. Thomas challenging the ED summons. Pursuant to the directions of the court, the officers of the KIIFB answered the summons and appeared before the ED. The matter has been posted for further hearing on 22nd May. Stay tuned. The Bombay High Court has ordered the Secretary of Health, Government of Maharashtra and the Commissioner of Police Thane to take legal action against a medical officer for gross negligence in conducting the post-mortem of a deceased in a murder case. The bench of Justice Prithviraj K. Chavan was dealing with a bail application filed by the accused in the case, who allegedly murdered the man in the year 2020. The accused filed the present bail application on the ground that the post-mortem report did not specify the cause of the death of the victim. The medical officer had mentioned in the post-mortem report that the cause of death would be given after receiving the chemical analysis report. Last year, the court had directed for a committee to be constituted to ascertain the cause of death. The committee's report found several issues with the post-mortem report prepared by the doctor who conducted the examination at Rural Hospital, Murbad. The report was issued on the letterhead of his private hospital, despite the post-mortem being conducted in a government hospital. He failed to submit any report from the official government record. Additionally, the findings in his report were inconsistent and contradictory. The injuries noted by the doctor did not match those recorded in the inquest Panchnama. Also, he neglected to send brain samples of the deceased to the FSL in Thane. Thus, the court ordered the state to take cognizance of the report and to initiate appropriate legal proceedings. And lastly, the Kerala High Court has stated that a scheduled caste community certificate cannot be denied to a child born out of an interreligious marriage merely because her father was a Christian and did not convert to the Hindu community. In this case, the mother of the child belonged to the Plea community and approached the High Court against non-issuance of a community certificate to her minor daughter for educational purposes. She submitted before the court that her daughter faced the prejudices, social disadvantages and sufferings of being a Plea community member. It was also argued that her daughter had a community certificate showing that she is from the Plea community. However, her application for a community certificate for educational purposes was rejected. On the other hand, the public prosecutor submitted that there was no evidence to prove that the petitioner's daughter faced difficulties or hardships because her mother belonged to Plea community. It was submitted that since the petitioner had an interreligious marriage and not an intercaste marriage, her child could not obtain a Plea community caste certificate as the child's father is a Christian. Justice Devan Ramchandran stated that the indignities, humilities, and the social handicaps faced by a member of a particular community should be the determinative factor to grant or refuse the caste certificate of that community. It was stated that factors like the interreligious marriage of her parents or that her father is a Christian would not determine her caste unless contrary evidence was available. Therefore, the writ petition was allowed and direction was made to the Revenue Divisional Officer to issue a community certificate to the petitioner's daughter. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.